everyone, I'm Burt with Burt, Beckstrand and Young. As you know, I answer legal questions that my subscribers most often make. So if you want me to answer your legal question, just click subscribe, send me that question, and I'll do my best to answer it. Now, I've had a lot of people ask me recently how to file a divorce in Utah. Well, divorces are a lot more complicated than people think. They're very similar to closing a business. There's a lot of issues that the court must resolve before it can dissolve the marriage or the business. Like closing a business, the court will decide who pays the creditors and how the leftover assets are divided. Additionally, the court will need to decide in a marriage who gets custody of the children and when both parents get to spend time with the children. Courts will also need to decide who will pay support for the children and who will pay support to the ex-spouse. Marriages that are only a few years old, where the couple does not have assets or debts or children, may feel comfortable not using an attorney in their divorce. All others really should use an attorney in order to get everything that they're entitled to in that divorce. Now, Utah allows both fault and no-fault based divorces. Most people will choose to file a no-fault divorce because it's easier and less expensive, and really there's no benefit to go the other way. Now, before filing in Utah, you must be aware of the residency requirements, the grounds for divorce, the cost of divorce. If you cannot afford the court fees, you can ask the judge to waive them. Once you're aware of the requirements, you'll need to prepare your forms. The forms will need to be signed in the presence of a notary and filed at the clerk's office in the county in which you live. The clerk will charge you a $310 filing fee, and within 120 days after you've filed that petition, you need to serve that petition on your spouse, along with the summons. Now, the summons is a document stamped by the court that tells your spouse they must answer the petition or they will default on the case. After you serve your spouse, he or she will have 21 or 30 days, depending on where she lives, to file a response to your petition. If your spouse files an answer, both of you must disclose to each other a financial declaration. Now, this form requires that the parties exchange financial information, including a list of all your assets and debts. If your spouse does not respond, then you may ask the court for a default judgment. And this means that you get everything that you've asked for and your spouse doesn't have an opportunity to protest. Keep in mind that these are the first and initial steps to filing a divorce. There are other steps that follow. Click on my other videos to answer any other divorce questions you have. And remember, if you want me to answer your legal question, click subscribe and send me that question. Have a great day.